Francis, the keynote speech. Authoritarian Playbook, Security, the Law, and the Silencing of Dissent. Now, around the world, and even at home, we have been witnessing restrictions on democracy, the closing down of civic space. The writer Gideon Ruckman released a book last year called The Age of the Strong Man, in which he says this is now what defines our democracies, that we are being led by people who want to show that they can curtail on the freedoms that we've gained, whether it's with Donald Trump or Benjamin Netanyahu or Erdogan in Turkey or Narendra Modi in India, until recently Duterte in Philippines and Bolsonaro in Brazil. It is a trend going on around the world, and we are witnessing it now in our region. So they're doing this in the name of security, in the name that this is important for us, and we're being told if we don't agree to it, then we are going to pay off. Now, our panel this afternoon brings in influential voices, and they bring in a lot of experience in this area, from the law, from international institutions, and from human rights. So to begin with, I want us to frame our discussion asking, what exactly is this authoritarian playbook? So to all panelists, 5 minutes each, you might want to tell us, when we talk about the authoritarian playbook, what are its most visible tactics that you see, legally, politically, or through security institutions? And for Kenya, is this something new? Or is it old authoritarianism that is now being dressed in democratic language? I want to start with you. Maybe Evans, you want to start off?
Good afternoon. Thank you very much, ladies and gentlemen. Now, I will, forgive me if I sound like a teacher in the afternoon. I don't know if your mic is better. Yes. Don't worry, Irongo is my brother, my client in other life. He has tasted authoritarianism both in the field and on the ground, so he knows better. So I'll take you through what will sound like your typical constitutional law class, but I'll try to make it interesting. And what we want to see in my 5 minutes presentation is how does authoritarianism look like in practice. Now, 3 concepts. Luciana, I know you'll be taking notes. We'll be looking at what we call authoritarian legalism, the national security doctrine, lawfare, and what we call the state of exception, because these are the tools that these despots use. Now, authoritarian legalism, what is this? The use of legal institutions and language to legitimize repression. You've had a certain strong lady somewhere use the police to clamp down on quote-unquote foreign invaders into her country. That is the language. In my country, Kenya, we are told that we have to clamp down on terrorists that are using social media to do ABCD. A very important person in this country once told us that social media is responsible for what? War crimes, and fueling war crimes when the person was visiting some court in this country. Use of legal institutions and language to legitimize repression. Then we have the national security doctrine. We are doing ABCD because we have to secure the country. We have to protect the countries from invaders, from people who are trying to jeopardize peace and order. That's the language of national security doctrine. Then there is lawfare, the manipulation of legal norms to delegitimize the opposition and civil society. Section 6 of the cybersecurity law that was appended the other day. That's a very wide area to use this manipulation of legal norms. We are told that a certain institution, a committee there, will be responsible to protect our children, to protect people from certain vices, morality, cultism. Charles Kanjama and his team spent some considerable part of time dealing with the Shakahola massacre, and out of that came some bill. The bill is still pending in Parliament. and it should deal with cultism and all those kind of things. Why will you have Section 6 of the Computer Cybercrimes Act to quote-unquote deal with religious cultism? So that is lawfare. State of exception, that in certain contexts we have to depart from the law. We have to suspend legal provisions so that we can restore peace and order, sanity. How many of you remember during the Gen Z demonstrations, we had the military sent out to the streets. And when some of us were asking and saying, Article 58 mediates when the military should be deployed and the context and the manner, there's the substantive and the procedure. Now that is not idle, because if you go back to those of you who've studied political science, there's a political theorist from Italy called Giorgio Agamben. Now Giorgio Agamben is actually the formulator of this doctrine of the state of exception. And Giorgio Agamben speaks of reducing you or stripping you to the bare life. What was happening to Besigye? You don't kill the guy, but just ensure that he is stripped to the bare minimum so that he learns a lesson. So we leave you to your biological existence, but we have to use political structures to reduce you to your bare minimum, to teach you life as it should be. I don't want to go through Agamben, but you probably read on him. And that's the same with Tundu Lissu. Now, quickly, because my time is out, how does the architecture of the authoritarian playbook look like? So legal engineering and control, vague and overbroad laws on sedition, cybercrime, and false information. Again, Section 6 of the cybercrimes law that was enacted, and the entire act indeed, a lot of sections are being targeted at using the decision in Bake, is still on appeal, Bake versus the Attorney General. You use broad language to ensure that you criminalize dissent and criminalize speech. Criminalization of protest and assembly. My brother here once went to the street asking questions about, why are you treating our Kenyan women like this? Why are you beating up women on the street? And he was, quote unquote, arrested to be arraigned in court for, quote unquote, not giving notice about his demonstration and causing disorder, those kind of things. Security as a political narrative, we've had it from Mama across. We have to ensure that peace and order, these foreigners invading us, people giving us things that are foreign to us, that is the language of security, to protect our morality, to protect our culture. To delegitimize dissent. We protest on social media. People have been creating caricatures of politicians on social media and creating some coffins. The whole political class is up in arms saying, this is contrary to morals. We have to discipline these children. That's the architecture of the authoritarian playbook. Thank you very much.
We're talking about political domination as part of the authoritarian practice. I will probably turn to two other areas. One is economic domination, right? Creating a culture in which there's high levels of transactionalism, glorifying privilege, abuse of office and power as being the way that we make it, so that there's a whole generation of young people, apart from the Gen Zs that we see in the streets, whose career ambition is to be an actuarial scientist because it gives them the opportunity to be able to predict where contracts will come from and stuff like that. So I think that's the first area, so economic domination and the idea that corruption is how you win. The second one is cultural domination, and this is another chapter in the authoritarian playbook, and that is essentially the mind games that come with infiltrating social movements, the games that are played on social media with regards to troll farms, the bloggers, the entire group of people who are now for sale, or mercenaries that can be unleashed on anybody, and sometimes different victims, on both sides of the spectrum. They're really guns for hire. But infiltration, division on the basis of ethnicity, or on the basis of one's views about sexuality, for example. Amnesty was hammered, I think, just in August last year for supporting the Gen Z protests, because they argued that essentially through the protests we wanted to introduce the right to same-sex marriage. Right? It was amazing. I mean, I was like, whoa. And the phrase that they used was the right to kiss campaign. They said Amnesty has developed a right to kiss campaign. I thought the phrase was a good one. And I actually asked my communications people to take note that everybody should have the right to kiss who they want, as long as it's consensual. But my team thought it was too dangerous to open up that flank, so we didn't touch it. The other thing I think is two concepts that I think we have to become much more adept at disrupting. The first is TINA, not Tina Alai, the vice chair, but TINA, there is no alternative. TINA. The second one is whataboutism. Once national public interests begin to focus on a particular issue, there will be always some clever person that says, what about this one? What about that one? And all they're trying to do is to dissipate the energy that's beginning to form and the creative movement that is developed in one. So these will be the two other chapters in the Authoritarian Playbook.
What I find is the current situation reminds me of the quote by Charles Dickens from his book, A Tale of Two Cities, that we are in it was the best of times and it was the worst of times. And that is because when you take a sweep globally on what is happening based on our reports as Office of the High Commissioner for Human Rights, you find that even within the authoritarianism, that there are pockets of best practices. So at times you are put in a corner, you're not so sure what to really focus on. And also you find that there are bad practices. So it's like you're making one step forward, then two steps backwards. And in terms of the trends, allow me to unpack what this translates in relation to human rights. So the first trend is that we are seeing shrinking civic space and human rights defenders being targeted. And when I talk of human rights defenders, it includes lawyers, because most of the time we tend to think of other people from the community who take to the streets. It includes lawyers, it includes journalists, and also it has been broadly defined to include also judicial officer. So we see this category of people being threatened. And for example, the European Council, they documented that 57% of lawyers reported having faced threats. And I'm sure also in Kenya we have had such incidents where lawyers, because of taking certain cases, they have faced threats and they self-censor, so they don't take cases. So there's that aspect of shrinking civic space. The second one is in relation to curtailing the right to public participation in public affairs, and this includes also election. And here we see a trend also of the technology being utilized, whereby you find AI being utilized to create echo chambers to influence how people vote. And we need to look out for that. How are we being somehow try to be influenced to perceive candidates in a particular manner? So we see increasingly there is that aspect of curtailment of democracy and the right to public participation in public affairs. The third one is in relation to digital space and human rights. And here we are seeing increasingly increase in online violence, not only targeting people based on their gender, but also based on the decisions they take, whether it be their public officers or judges. For example, the Special Rapporteur on Independence of Judges and Lawyers has documented increasingly in other jurisdictions, and including Kenya recently, judges being trolled, being targeted. And what that does is it makes judicial officers to somehow want to pedal back on what they would want to say boldly. The fourth area is in relation to right to the freedom of association and assembly. We are familiar with the trends in Kenya and also within East Africa. And also this trend is seen in Europe, for example, in France as well, Spain, where increasingly you find laws of public order being tightened up to curtail people to exercise their rights, and when they are arraigned in court, often being charged with thumbed up charges, or they're being charged with charges which would make them think twice before they take to street. We are familiar in Kenya where human rights defenders were being charged under the Section 2 of Prevention Against Terrorism Act for acts of terrorism. And this is not only unique in Kenya, but also in other jurisdictions. The Special Rapporteur on Counterterrorism and Human Rights has seen increasing trends whereby human rights defenders who are going to the streets to advocate for certain rights to be protected, being tried for acts of terrorism. And you find in most jurisdictions, they don't have clear definition of what terrorism is. The fourth one is in relation to freedom of expression and opinion, where you find increasingly journalists are being targeted, their safety are being jeopardized, and therefore you find also journalists, some are being careful on what they want to report on. Increasingly we are seeing cases of investigative journalism that we used to have bold, not only in Kenya but in other jurisdictions, that taking a back seat. So that's another trend that we see. And ultimately what is scary in all this, incidents of extrajudicial execution and incidents of enforced disappearance. And so with that, it makes people to shy away for being bold in pushing for human rights. And they're doing this within the legitimacy of law. Because the challenge you find, even when you want to intervene using international law, often there'll always be that limitation of what the domestic law provides. And therefore you find it becomes challenging unless the human right that is being scrutinized, it falls within the category of jurisprudence. So that's what we see happening worldwide. And it's not only in Kenya where we're facing these challenges, but also other parts of the country. Last but not least, other observations I've seen is that it seems you're also dealing with the battle of narratives, whereby we are being pitted against one another to have a particular narrative, human rights activist defenders being perceived as disruptors and unnecessary disruptors. I always find it amazing when I interact with some of our people who are in public service, not only in Kenya but also other jurisdictions, where they perceive human rights defenders within an unstaked actor sphere as a disruptor, as trouble maker. So we have to worry about that battle of narratives. And the other thing that I invite us to reflect upon is I see an attempt to try to influence our perception and also to influence our perspective, and by extension that impacts on the posture we take as individuals. So we also have to question what exactly the authoritarian trying to do in making us to perceive people in a certain way. So we always have to be alive to that. There's nothing new under the sun, and it's just the same playbook. So I'll say that for now so that we have time to interrogate in other aspects. Thank you.
But unfortunately, the rest of the country did think it would matter because it was seen as a problem for Muslims. So if it is Muslim boys along the coast being disappeared, that's okay. And now we've seen how many years later that same law has come to affect everyone. And now we realize how important it was for us to have solidarity at that time. Because at that time, unfortunately, most of us didn't think it would affect us. We thought it would affect one community, and if that affects one community, then we are okay with it. So I'm going to go to my next question with Evans. You've spoken very well about lawfare. We want to hear a little bit more about that. How are laws being used to curtail authoritarianism? How can we fight against those laws, looking at the successes we've had, for example, against the BBI, and what do we need to look out for? One of which you've mentioned is the Computer Misuse Act. So how is lawfare a very important part of the authoritarian playbook?
Law presents a paradox. Law can be both a shield and a sword. When citizens seek protection under the law provides us with respite, the law is a shield for us. But when it is weaponized, the same law works against them. Look at the so-called Public Order Act. Mr. Isaac Hassan's clients will always invoke the Public Order Act when trying to remind us that we need to notify the OCS. We need to notify CGU before we walk down and demonstrate. And some of these demonstrations are impromptu. We have seen, and increasingly, look at what is coming in from Parliament, Cyber Crimes Act, and I dare say the judiciary as well. You will see some of those decisions and you ask yourself, what was this particular judge thinking? Security Laws Amendment Act. Look at what was done. I'm sorry, this I have to say. I'm known to speak my mind irrespective of the consequences. Look at what Justice Wasilo did the other day. What was that? Going against an express provision of the Constitution and essentially equipping an endemic blue code, a culture of police impunity and making it difficult. And then you hang it to us because it's the judicial pronouncement that we tell us it's law. It is not. That decision is mutilatingly weak. It does not stand the master of law. It only gains some respect because it comes from an institutional premise, but otherwise that is not law. And that is what is happening. You see them in the magistrate's court. Look at what we do with bail and bond. Weaponizing discretion to facilitate repression and authoritarianism. What are the consequences of what we've been seeing? The consequences are the erosion of public trust in institutions. Kenyans have very little trust in particularly this special animal we have in this country called the politician. We have zero trust in them. A lot of institutions don't enjoy public trust at all. Self-censorship. People don't want to post on social media because we are afraid, oh, will this land go into trouble? We had some politicians the other day pontificate moralism by telling us, oh, tell your children to keep away from social media. The same politician who you know has mistresses all over and steals from us, pontificating and telling us what to do. Weakening of accountability mechanisms and the rise of impunity. I don't need to tell you, you live in Kenya, you know what happens in this country. Shrinking of the civic and digital space. You've seen what they have been trying to do, and the committee that they are trying to establish in section 6 of the Cyber Crimes Act. That committee will have the authority to pull down posts, to pull down websites. Never mind that the judiciary has authority to examine posts and to examine what is problematic under Section 46. But nonetheless, a committee composed of largely executive mandarins is given power. So that will contribute to the shrinking of the civic space, and politicians, if they don't like your face or your name, they will have the authority to do, the power to do whatever they want with you. The strategies, how do we counter these habits? Number one, we need to have a consistent public interest litigation, strategic use of regional human rights courts. Let's keep at it, let's ask our questions. Civic mobilization, Amnesty, ICJ and the others have been involved in this. Bring in lawyers, bring in activists, bring in citizens. Let's keep mobilizing, asking our questions. Transnational solidarity, let us build coalition amongst like-minded people around international norms, the African Charter, the ICCPR, the watchdog networks. Let's build consensus around those. Digital resilience, we can use technology to document abuses, to counter disinformation, and to organize securely. What you're seeing people do around the Tanzanian massacre, we use the digital space to counter what propaganda the state and the oppressors are trying to do. Thank you.
I know that growing up for the longest time, I looked up at the West as progressive democracies in terms of freedom of expression, in which they would say nothing should be limited. We should be able to express ourselves in every way. Yet this country is now saying if we apply for visas, we have to give them our social media handles so that they can check if we've ever been critical of them or their friends. So it's interesting how the authoritarian playbook is playing right now and makes us question some of those values that we thought had been settled. So Bivalai, if you look at these trends globally, how are you seeing some of those freedoms that we thought are now cast in stone? How are we seeing those freedoms being pulling back in some of the countries that used to be the protectors of human rights freedoms?
Thank you very much for that question. One of the clear trends is being quick to label certain conversation as hate speech. And yet, when we look, we don't have a clear definition of what is hate speech. A state can just decide arbitrarily that if I say I don't like your bald head, that is hate speech, and they can say it's ageism, you know, making it subjective. So that's one of the observations that the Office of the High Commissioner has observed in terms of curtailing freedom of expression and using digital through digital platform, whereby people now are self-censoring, and that is being used also to curtail journalists. There's a particular lawyer from Hong Kong, Kevin Yang, who was disbarred by their bar association because of her comments calling for independence of judiciary and prosecution in his country. And you see that's curtailing his freedom of expression, and he was just making his comments online. And I'm glad that in Kenya we have an independent bar that will protect the rights of citizens. So what is the UN currently doing in relation to that? It has a working group that is looking at how do we ensure safeguard of the freedom of expression, and at the same time ensuring delicate balance that we don't go as far as incitement to kill, because it's a delicate balance between me saying I don't like Kibata, then also what if somebody uses that and goes ahead and, you know, takes his life, God forbid. So it's a thin line, and it's a deliberation that we are currently looking into, and we need to give it a careful thought. Tied to that also, I think we also need to look at another area of concern, is the use of artificial intelligence to generate images, generate information that is fake, and also by extension using that to influence decision-making process that are discriminative in nature. And so far, one of the red lights that has been highlighted is what has been dubbed as techno-solutionism, whereby we over-rely on digital technology in decision-making. Let's say, for example, when it comes to allocating people houses, relying on algorithms to allocate housing to people as opposed to actually looking what are their actual needs. Or when it comes to judiciary, for example, as seen in other jurisdictions, over relying on AI in determining whether a person should be given bail or not. So it's a delicate balance, and this syncs well with the quote I started with, that we're in the best of times and the worst of times, but I'm sure we'll find a clear way forward if we use human rights standard as our barometer and as our compass in asking the question, at the end of the day, does this advance the human dignity of the subject matter? Does it ensure that their rights are safeguarded? And those who are vulnerable, do we ensure that any decision we are making in relation to media laws in as so far as they disseminate information online or discussions that are taking place online, it does not make them to be worse off than they would have been if we had not employed a use of digital technologies.
To human rights. Irungu, you, in your work at Amnesty and even before, you engage almost daily with citizens who are part of movements confronting power. So what patterns have you observed in how government responds to ordinary Kenyans, intimidating them and making it difficult for them to protest or to push back? And tied to that, my next question is something ICJ is very passionate about, and that is the criminalization of poverty. Because even during pushback and in disappearances and in killings, the majority of the people who tend to be killed come from low-income families or they live in the low-income neighborhoods of Nairobi. It's very unlikely for the police to go to Runda and shoot people. So how do you see these trends in how the government responds to human rights workers and human rights defenders?
I mean, I'll test one hypothesis. So over on the left here, on my laptop screen is a QR code. And that QR code takes you to Uganda. It goes directly to his email address. Some of you have seen this. It's the campaign essentially to have Nick and Bob released. By show of hands, how many, and there's no criminalization in this question, how many of you have actually written using this QR code? First of all, how many of you have seen the code before today? Just raise your hands. Okay, 2. Hey, our communication channels are not working. And of the 2 of you that have seen it, how many of you have actually sent the email to Museveni? Okay, no. All right. So as we're talking, and because I know you're all able to multitask, I'm going to ask you to take out your phones. Anybody who doesn't have a phone, I can lend you mine. Smartphones, take out your smartphone, point it at the QR code. It'll take you to a place where you can send a message directly to release both Bob and Nick. I know I'm chewing up my time, but this one is probably important. And my request is just simply send an email. It takes less than 60 seconds to do that. The microsite was actually developed by the same person that developed a very useful tool for us around the Finance Bill 2025, if you remember that particular incident. And this, I will slightly work this into my response. So the first question is, how has the state been using, its power to criminalize, to divide, to disrupt public dissent, or even just political dissent? And I think the Prevention of Terrorism Act is one of the important places to start, particularly given what happened in July. Amnesty wasn't one of those organizations that didn't take seriously, for example, Operation Sanitization in East Lee back in 2014. We were very concerned. There's a whole report on it. And essentially, what was supposed to be a counterterrorism strategy turned out to be a huge corruption, rent-seeking opportunity for security officers, and a very bad immigration policy in itself. In 2019, we were very concerned about the enforced disappearances that ended up being targeted on Muslims and people who are considered to be either radical clerics or radical scholars. The case of Professor Nandwa, Law Society worked very hard on his case and other cases. And in 2022, we were at the Yala morgue trying to identify up to 40 bodies, that of whom 50%, when they were identified, were found to have had conflict with the Directorate of Criminal Investigation at some point close to it, right? And that many of them were people that had not been seen, or rather were last seen about 600 kilometers from Yala, right? So they had actually been picked, abducted, and dumped in that river. Despite the ability to track police cars and the ability to track police movements, we've never seen any arrests based on that. We saw a presidential promise during the campaigns, and we saw a decrease and the disruption of the unit that was responsible primarily for many of that. But unfortunately, what you've seen now is the introduction of new units that are perhaps even more lethal than the ones we remember in 2022. Let me come a little bit to the issues, because I think we've dwelled a little bit on the authoritarian playbook. Let me turn a little bit to the issue of, criminalization on the basis of poverty. The one thing I think we have to recognize is that abuse of public office is used most on poor and marginalized communities. It's just maths. If you try and do this to people who are middle class, have connections, there will be a backlash. As I told Cabinet Secretary Fred Matiang'i in front of about 500 police officers in, I think, 2020, I hope your children walk around with t-shirts that say, I am the son or the daughter of Fred Matiang'i, don't shoot me by mistake. And there was a moment in that room, I think even for the Cabinet Secretary, where I think he realized that actually once you open the floodgates for abuse of office, it can visit you very directly in your home as well. Can I go on a little bit and talk about the Freedom Playbook? Is that okay? So I think, let me just start with a couple of statements. First of all, that we must recognize that chaos, power, and privilege serve a purpose. It's not unintentional, right? Because many of us are still wondering, how is it possible that we could have we could have seen, sometimes live streamed, 130 young people shot by police officers paid by our taxes, right? How is this possible? So I think it's important to say that the chaos, the power, and privilege serves a particular purpose. Authoritarianism, I guess, survives or it thrives around narratives of fear, division, and control. And therefore, as human rights activists, it is our responsibility to actually disrupt those three narratives. Thirdly, that authoritarianism essentially operates in three spaces. The first is information. Control the narrative. Define the narrative. Make sure that there's no competing narrative. That's why you have to arrest bloggers. The second one is control institutions. Don't allow independent offices to be independent. Don't allow constitutional commissions to exercise their constitutional mandate. Defund them, intimidate their leadership, make sure that they do anything that which they have been designed to set up. Right? So this is the playgroup, whatever. I think there are three core strategies that are at least in the Amnesty Freedom Playbook. The first is research, strategic research and documentation. We spent a lot of time last year with the Police Reforms Working Group essentially pumping out with the Kenya National Commission on Human Rights statistics, data and information. And the IPOA reports, the Kenya National Commission reports were critical in terms of that. The second area was really around the issue of disrupting the public narratives and public education. So there is a wonderful toolbook that was released about a month ago on the Amnesty website called Rights Revealed, and it's really good in terms of developing human rights education around this. But just if I pick on a couple of things that we've done recently, Rose Njeri, the cyber, the techie that was locked up for 3 days in May, recently received an award from Time 100 as an emerging leader. And when Time called us and said, can you verify Rose's credentials, like is she legitimate? And we said, of course she is. We took a decision to actually invest quite a bit of resources in making sure that her story, this particular part of her story, would be told as loudly as the story when she was arrested. And we did that particularly because we wanted Gen Z activists, the creatives, to recognize that sometimes the darkness that can be visited upon you for being bold and courageous and speaking truth to power can also be visited by such tremendous light that you would never have imagined. Rose Njeri came back from New York over the weekend. She had never traveled before, never been on a plane, not even domestically. And she was in New York. She received her award with a bunch of rappers, designers, and I think climate change activists, people I didn't even know, but she was very impressed about. The only person I was impressed about was Rose Njeri. And I think these are the things that we sometimes fail to do, which is we don't go back and elevate the 4 producers, for example, who got arrested for allegedly being part of Blood Parliament. We don't go back to Rose Njeri. We don't look for Joki, the woman who exposed Shah Schiff, and actually elevate her so that you send a message that those people who are courageous, those people who are brave enough to take on things that are important for this country, not only win on those small little battles, but they can become inspirations for others. And then the last one, I think, is really thinking about how we mobilize people power. Without the medics for Kenya during the protest last year, we would have seen much more in the way of fatalities and injuries. Without mobilizing the Law Society branches, not the council was already mobilized. But if Mara and Faith and Gloria and Tessie and all that council leadership that was there had not generated ground level branch leadership on legal representation, many of those young people would still be in jail today, right? Just to be clear. There were at least 3,000 arrests conservatively, right? Most of those people, with the exception of the Porter cases recently, came out within 2 to 5 hours, perhaps 2 days. In the case of the Porter group, we have had people in there for 103 days, simply because they were not able to persuade a magistrate or a judge that the bail terms were set much too high for their means, and therefore they couldn't be released. I could go on, but I think I've talked for a bit too long.
Those countries that define themselves as constitutional democracies, in which Kenya is one, the judiciary is usually the last pillar we have to push back against authoritarian rule. So how have you seen our judiciary in Kenya playing out in protecting us? and in protecting our constitutional order. And what should be in the legal profession? What should lawyers, what should ICJ Kenya, Katiba Institute, the Law Society, what is it that they need to look out for as this authoritarianism gets worse and worse?
How to speak about judges again. Anyway, history teaches us that authoritarianism rarely announces itself in uniforms or in coups. It often arrives in the language of security, order, and the law. In the Kenyan context, we have had very good cases to cite of judicial officers who know their role and mandate. They have been what others have called great judges or great magistrates and have stood the test of law. Then we have the converse, people that we always worry about, and Kenyans, we know them. I don't need to mention their names. So essentially, Kenya presents a mixed bag. And we have a problem, and the problem goes all the way up, including the Supreme Court. The Supreme Court's record in terms of protection of civil liberties and freedoms and rights, our rights generally, is really a mixed bag of presentation. We have areas that need to be worked on. Certainly bail and bond is a worry. Bail and bond, despite the bail and bond policy guidelines that was worked on so tirelessly by very many people, and the bail and bond policy announces constitutional provisions and constitutional principles. There are those magistrates who still think those are suggestions. And they can be very rude and brazen at it. And that is why some of us, because of trying to keep our sugar levels down and to just keep respect for the bench, we avoid the criminal courts, because it can be annoying. We have the reasoning around Article 24, the limitations clause, and the reasoning around constitutional limitations. Woeful and needs improvement on. Because if you look at Article 24, for example, Article 24 of the Kenyan Constitution is verbatim the state versus Makwanyane, the very first decision out of the South African Constitutional Court. But how is it dealt with by our courts here? The constitutional Article 24, our limitation clause, is dealt with as if it's English prose, as if it's an article out of a newspaper page. And no more pathetic can that be than a decision from the Court of Appeal, is it Joguna versus the Republic, where the court, in its wisdom, decides to tell us that the death penalty is constitutional. And I remember asking this very simple question to a judge on that bench, privately. Article 24 allows you to limit a right, not to extinguish a right. So when you say that the state can validly execute someone as a penal consequence rather, are you endorsing limitation or are you endorsing extinguishing? So people go to the bench and you can't tell what are they about. And this is where I always make this noise. There's a group where Senior Counsel Kanjama and I are, and I'm usually a problem in that group. I'm one of the youngest, but the most problematic in there, because I always ask, how do you recruit for the bench? We need ideologically refined persons for the bench. Not everybody qualifies to sit on the bench. My good friend, Professor Oanthile Dingake from Botswana, we have written a piece on him on this month's platform. He says that a judge has to be ideological, and when you have ideology, you're disciplined in terms of how you reason with the law. Because the law as E.P. Thompson in a book called Whigs and Hunters tells us, the law has to serve certain ideological function. The law is not empty, it has certain values in it. So if you're not disciplined ideologically as a judge, you have a problem. You can't be seesawing as a pendulum. You cannot be a chameleon as a judge. Justice Kachale told us in the morning, and I repeat this after Waiko, these values we profess, do we believe in them as principles, or do we pronounce them just as a fact, as a matter of earning a living? Thank you.
For many of the young men and women that we've lost, it's either been killed, it's been disappeared. Intimidating the parents, telling them this is what we'll do to your children. But it's not limited there. Civil society organizations that speak out and have been promoting human rights and democracy are also singled out. We've seen attacks on the KHRC in the last 10 years. We've seen sham charges being brought against Africa, against Uhuru, against Turkey Africa. Internationally, the United Nations itself is now under attack from some of the powerful states in the world. The United States has withdrawn from the Human Rights Council. The UN Institute for Palestinians is being criminalized in some countries. So what does this say about what we need to do collectively? Knowing that if we are going to defend democracy, we are going to defend our rights, that powerful forces will come against us. So what do we need to do together? And secondly, how do we fight institutions that are more powerful and better funded than we are? So there's an element of how we have done this work relying a lot on funding coming from outside Kenya, and that funding is drying up. Does that mean for us that if we are no longer funded by Europeans and Americans, we will not be able to fight for those rights? So there are many elements to this question. Each one of you can give us in 5 minutes, how do we fight back, knowing that we are all going to be attacked, and how do we fight back when we are don't have the resources that the others have?
Okay. All right, I'll take an initial stamp. So, I mean, you can't imagine, I wish Hanifa was here, Hanifa Adan, to tell you the number of cases that she's had to manage arising from the violence over the last year and a half. You have people who have become musicians in order to raise money for surgery. You've got people who worry and still have post-traumatic stress because their son was shot with a tear gas canister here in Mombasa, but there wasn't enough evidence to move that case to even an inquest, let alone a hearing. You've got people who have lost jobs. Many of you saw the BBC documentary, The Madams of Maimahio, the former sex workers, those girls that came out, barely women, who came out and told about their experience. When the Cabinet Secretary Interior said that this was all fabricated and generated by BBC for payment, and that they had paid the sex workers to tell these stories, the very little businesses, legitimate non-sex work business that they had developed, crumbled overnight as they were seen as people who had told the secrets of their community to the public, in fact to the international community. They lost jobs, right? And I think the impact I feel is not so much, it is a major concern to human rights organizations, particularly NGOs, but I think, to be honest, the model of the NGO was dying anyway. It's been dying for 10 years. And essentially what is killing it is not necessarily the repressive shrinking civic space, which is a factor, but it's actually the shrinking budgets that are now available to embassies and bilateral and multilateral institutions. So we have no other ways, as they say, to begin to look at domestic resources. Until Kenyans are willing to fund human rights work in Kenya, I don't think we have a certain future for this work. In the case, several cases now, as Amnesty, we've started now asking people, we've been appealing for support for persons at risk. And we're starting to see a bit of a muscle there. So just to give an example, recently somebody gave their home to a visitor for 3 nights at no cost. That was used as a safe house. There are people who have essentially contributed financially, others have lent vehicles, etc. I could go on. So you're beginning to see that become a bit of a reality in many ways. And we need to encourage it, I think, ICJ also including. I wanted to talk a little bit about, one thing that we did talk about, well, actually it's another resource in some ways. We, I think, are still frightened as a human rights community of artificial intelligence. So our first lens is the fear factor, right? Its ability to distort, to disinform, etc. What we are not yet harnessing is the power of artificial intelligence to produce authentic information. Just give you 2 examples. The Amnesty, this is trade secrets coming out here, so pay attention, and please don't tweet it publicly. It took us 5 minutes to do a statement on the re-emergence of Mwabili Magodi recently, using AI. It took me 15 minutes to prepare a presentation for very senior government officers from South Sudan who had come to Kenya and was looking for human rights-based advice on how to develop a strategy and policy and law on hate speech. 15 minutes. It took me 3 minutes to develop a orientation journey for my new treasurer who's coming in for the next 2 weeks. And it took me 5 minutes to prepare for this presentation this morning using AI. Now what am I telling you? Is that if you harness this tool, you will be phenomenal. Even if you go before Evans Ogada's class, you will sound like Firoz Novoroshi. So that's one point. I think there's a resource that can make our work much faster, and it can also, make our work much tighter. Of course, you need to do editorial work, but I think that's the first point. Let me come to just one last point. And this links a little bit to, I think it was a question that Waikwa, it was a comment that Waikwa made, and maybe it was a comment, both a question and a comment he made earlier. And Martha's comment, and I think a bit of anguish we had in the room, which I think Jedida spoke to, which is what happens to people when they get into state structures, right? I just want to give a kind of a take on it. I think one of the things we have to begin to take seriously, that it is our business, it is our responsibility to encourage professionals to break away from authoritarianism, right? State officers have to be encouraged to essentially do the right thing, and we have to develop that as an art. I'll give you an example. We've talked about judiciary. We've not talked about the military. We've not talked about the National Security Council. We've not talked about State House. We've not talked about the Ministry of Interior. These are places in which the power is not only resident, but it is exercised sometimes without due care and concern for the impact that it will have out there, right? I'm not saying people don't know what they're doing, but I'm saying that their interests and our interests do not align in many places. So one of the things that I think would be useful to do is to start thinking about, instead of calling out state officers, why aren't we finding ways to call them in to the things that matter to us? How do we find the language to do that? And I'll give you a very practical. I'm not a state officer, although some people think with a panel of experts, I somehow have left Amnesty alone for the last 3 months. And I can use that, I think let me use that name because it will give you a bit of a context. Wajiko Thiga, who is the DCP youth leader, was picked up, one of the first people to be picked up on terrorism charges. And she was picked up, I think, then she was released, then she was rearrested, if you remember the very dramatic scenes outside the courtroom. So I was in a panel about a week ago, and we were talking about the use of counterterrorism with Nerima Wako. And she stood up, and she made a very passionate, presentation on her experience of being arrested as a terrorist and being placed in a section of Langata Women's Prison that was dedicated for extremist offenders. She was put in a room with a couple of other people, with a woman that had gouged the eyes out and pulled the hair out of a hairdresser simply because the hairdresser had pulled her hair too hard, right? And by the time they got to this cell, she had also beaten up one of the warders savagely. The person had to be hospitalized. And then they were put in this cell with this woman, and one of them was told to braid her hair by the warder. Right? So she told this story. And then she looked me dead in the eye across a room of 200 people, and she said, and when I was in that courtroom and I was looking for support and I knew we had big human rights organizations in this country, where were you, Amnesty? Right? And it was very powerful, right? So I breathed. And of course, the the response that I went to was to apologize. Say, we were not there. We did not protect you. You were protected by Law Society lawyers, and actually, to be honest, we had discussed with some of the lawyers about assigning lawyers to those cases, but she wanted to see amnesty there, right? So I apologized, and essentially I was called out publicly. So it's actually it's on YouTube at the moment. It'll be there forever. And it's a good reminder for us to have the humility to recognize two things. First of all, we're not saviors. We cannot be everywhere. But where we are not, there is an impact. So we have to build structures and a resilience that allows us to use the brand, use the strength that we have to protect people, right? So this is kind of where I went with that. 2 days later, I get a phone call from the lawyer who's managing another case, which wasn't a Potter case, but it was a theft, robbery, and possession of stolen property worth about 3.2 million that had happened on July the 7th. I'm sorry, I know I'm going into anecdotes. You don't want to talk anecdotes. Is it okay to continue a bit? No, it's okay. All right. The rest are asleep. They slept a long time ago, right? So she calls and she says, listen, there are 7 people, 3 women, 4 men, who have been essentially held because of bail charges, the bail terms that are too high, 100,000. And this particular magistrate at Makadara does not want to reduce this. They've tried 3 times. It's not going to happen. Could you come to court and just simply stand with the victim, with the suspects? So we did the analysis internally. We're like, wait a minute, hold on a second. These are suspected of crime. It's 3.2 million shillings. There's no evidence that they are human rights defenders, no evidence that they were involved in the protests, but we decided to go anyway. And then a phone call to Mara Kabata said, can Law Society also come? Now, there's something about the Law Society that I don't quite understand as a non-jurist, which is when the Vice President, Vice Presidente arrives, he just takes over the case, right? So he walks to the front of the courtroom and says, I am appearing for the 7th. I don't even think he had read the file. He was briefed as he walked into the courtroom. Within 15 minutes, the bail term had been reduced from 100,000 to 30,000. Right? And those 7 suspects were allowed to go home. 5 of them had been at remand for 103 days. Right? Now, the reason I mention this a little bit is if the first call was a call out, it was a public call out, I felt a bit embarrassed. I went back, I told the story to the staff, I said, what would you have responded? The second one was a call in. This is the point I want to make, is that if we can continue to find ways of reaching out to professionals, state officers, and calling them to do the right things, then we may have slightly better chance than watching the people that we knew well, we worked with, whose skins seem to have hardened, their heads seem to have become more dismissive, and there is a don't care attitude. And worse still, they seem to be under the influence of very dangerous people. Perhaps would have a better chance. It's provocative, I hope it provokes a response.
Who truly believe we need to have our own autonomy as Africans and African states. So the first thing we need to do is to have a mind shift. What exactly do we mean by resources? Because the first image that comes to our mind is dollars, Kenya shillings, but let's look at other forms of resources, which could range from social capital that we have as persons. And that includes mapping amongst ourselves. What is the resource that I have that can contribute to a better human rights compliant environment? And given we are all lawyers, the first one is by virtue of being lawyers. And how can we use our education and expertise to contribute to a culture of human rights? I will just share at times when I interact with police officers of different cadre. There are those who want to do the right thing. And I wonder whether ourselves we've been able to ask if a police officer who is declining unlawful order comes to me to represent them, will I take that case pro bono? Most of the time we are so quick, we want to defend those who are accused because they will pay us. But what about those who want to oppose an illegal order? So that's a challenge for us. We should be willing to defend the public officers, particularly police officers, who want to make a conscientious objection to wrong orders. So that's one resource we have. Then the second one is for us to really do a mapping of the persons we want to influence and we want to reach out to. One, we need to find out their weaknesses, and in this sense, I'm appealing to us to look at law in a multidisciplinary approach, because we tend to want to look at it in a siloed manner. So I invite us to somehow wear a cap like Irungu, who is a political scientist. And what I mean by this, for instance, if you're to look example of our country and many other countries, you find that they care so much about their reputation. They want to look good. So how can we capitalize on that to ensure that they do the right thing? And I find this to be important because you find that recently in relation to Kenya, there were communications that were done by the various special rapporteurs, including the one on situation of human rights defenders. And she went public to indicate that she had written and there was no response to her communication. And immediately the media covered that and there was a splash on the nation. There was a response last week responding to the special rapporteur. Why? Because we want to look, we are the ones who set standards in Africa, because other countries copy what we do as Kenyans. So let's capitalize on that, because that is our Achilles, our underbelly, and my brothers and sisters in other jurisdictions also examine what is it that your country is really so much concerned about. If it is a business, for instance, how can you look in that arena to push for, when they are conducting business or engaging in multilateral agreements, there is human rights compliance to ensure that you somehow bend their neck, they do the right thing. So we really need to know the persons we reach out to, what exactly is their weakness. The third is documentation. I really find it important, and most of us as lawyers, do I say all of us? Though my friend Waikwa says that not every lawyer is a good writer. But I will insist that it's important we document what is happening around us, the violations, the best practice. Why? So we do not have our children in future dealing with this. We remember Honorable Martha Karua mentioning to us that what is happening now happened in the past. It's like a big brother effect repeating itself again. And when we do that, that will ensure that the generation that is behind us, they will learn from our strategies in terms of how do they get resources. They don't need to go to international agencies. They don't need to go to other countries to get resources. They just simply mobilize based on the experience they've learned on how we're able to surmount the particular challenge that we are facing. Last but not least, I will emphasize that it's important we focus on reaching out to non-traditional actors. I always find it amazing when I interact with others who don't work ordinarily on human rights, like a private sector. When I ask them, what do you think about human rights? The image they have is of people like Senator Umutata before he became a senator. They see human rights as remote. Yet if we break it down that human rights is important for them to be able to carry out their business, there could be potential resource to us because they want to have a conducive environment to carry out their affairs. The other non-traditional actor that we used to reach out well to in the 90s, that is from my reading, for example, religious organizations. They collect offerings, I believe in the mosque they collect offerings, right? In the mosques, I'm sure they do, right? Millions. Yeah, so also they can be very happy to support. So let's reach out to them. I'm sure they can provide support so we don't have to look externally, because increasingly we are having the tap being tightened and being given tough conditionalities in order to carry out human rights work. And what that does, you find many people are moving out of human rights work, and yet it's related to our day-to-day life. So that would be my 2 cents on how do we ensure that we survive once the tap is closed by international agencies. Thank you.
Most of it has been covered, but let us remember this, that authoritarianism today is not built in coups but on constitutions. The question is no longer whether the law exists, but whose power does the law serve? Ladies and gentlemen, if you remember Germany post-World War I, Germany had a very good constitution called the Weimar Constitution. And the Weimar Constitution was one of the most progressive and well-crafted documents of its time. It had a Bill of Rights, separation of powers in the Montesquieu sense. Everything was neat about the Weimar Constitution. The Weimar Constitution and its collapse led to Adolf Hitler and the Third Reich. And hence the term Weimar syndrome in constitutional law. Weimar syndrome meaning a liberal constitution, a good constitution, but it is attacked, it is weakened, it is denuded to the extent that it births authoritarianism. You can see the Weimar syndrome problem in the United States, whereby that man over there, I usually don't like mentioning his name, you can see how he is attacking the democratic institutions, the culture, the resilience of that 200-year-old document in the context of the United States. The people of the Republic of Kenya, this constitution has been tested, and we are not far from the Weimar syndrome and eventually collapse. Look at what is happening with our Chapter 6. We have a murderer in Parliament. All of us saw him kill and shoot dead somebody. And look at the way strings have been run around that case. He's in Parliament today. We have people with the morality of leeches vomiting on our shoes, pontificating and lecturing us every day. People whose, let me watch my language, I'm in public. How do we resist this? How do we deal with this? Ethical leadership. Charles Kanjama SC once reminded me in a private conversation somewhere in, was it Kampala or Arusha, that character is what you do in private when everybody's not looking at you. Ethical leadership. We have to have ethical leaders across board. Those serving in constitutional commissions, chapter 15s. Are you professing the values that we talk about, or are you professing them as a way of getting income? Because in the chapter 15s, I'm sorry, we have this phenomenon of recycling commissioners. And most of them don't think that they are supposed to be a fourth column to protect democracy and to play an accountability role, a regulatory role. They're supposed to be checking the three other branches. But some of them are more GOK than the traditional GOK. Chapter 15, we are calling you out. Institutional independence. What does Article 249 mean for us? And what does the rubric of Chapter 15 mean for us? We have to ensure that, particularly the Chapter 15s, the independent offices, remain independent. The judiciary, which is my concern of late, the judiciary has to remain independent, not only in word, but in action. Corruption and all the ills that have been bedeviling us as a judiciary, we need to call that out. A vigilant citizenry, we need to keep on asking those questions. We need to prod, we need to go to court, we need to demonstrate, we need to do everything to ensure that the Constitution is protected. We need to ask ourselves finally, and we need to remind ourselves this, that every generation must decide whether the law will be the master of power or its servant. Thank you.
What is the one thing each of you would propose in terms of structural or legal change, and what gives you hope that this playbook can be rewritten?
What continues to give me great hope in this context is young people and the bravery and the creativity that I see as they begin to demolish old ways of working that some of us who are not so Gen Z have prided ourselves in developing. So thinking a little bit more about how do you crowdfund, how do you crowdthink, how do you use open source technology, how do you work across generations, how do you work across ethnic groups and identity-based constituencies, and how do you remain leaderful is probably where my hope lies. In one sentence.
It is legal, it is moral, it is cultural. We have been brought up in Africa to believe particularly that our cultural norms, our cultural values mean nothing and cannot contribute to basically dealing with authoritarianism and all the ills we have. If you forget everything I have said today, I want to give us an assignment. There's a document called the Kuruk and Fuga. The Kuruk and Fuga is a document that was produced in the year 1263. It's a constitution of the Mande in West Africa. It's Kuruk and Fuga. K-U, K-U-R-U, Kurukan Fuga, 1263. I want you to look at that constitutional document because Kurukan Fuga, it is a document of the Mande. I want you to look at that document. And we who are lawyers here were taught to trumpet and vaunt the beauty of the Magna Carta 1215. See, look at the Kuruk and Fuga, and in my view, see if the Kuruk and Fuga is not a superior document to the Magna Carta. In my view, the Kuruk and Fuga is a moral political charter way superior than the Magna Carta. We need to tap into those values. Among the people of Burundi, this is the Tutsi, is their council, their traditional council is called Bashing Tahe. The Intahe is a symbol of justice. And for you to have drawn near to the Intahe or in charge of the Intahe, you are expected to exude certain moral characteristics. It demanded high ethical standards for you to draw to the Intahe. Why don't we go back to those value sets and ask of our leaders, you who has killed, you who is known to be a philanderer, steals from us in public coffers, are you worthy to draw near the Intahe? Back to our cultural roots. Vigilant citizenry, I think I've spoken about that. Let us go back to those traditional values. They will be able to help the law. Our politics will be more sanitized. Our morality, including our churches and mosques and temples, those have to contribute collectively to training and taming authoritarianism. Thank you.
We want us to remember, if we are taking the approach that law is both an art and science. I know at times lawyers, when it comes to law and science, it's like water with oil. But I want us to challenge ourselves, taking that approach then, how do we ensure that we have, in responding to the question, structural legal change? I think we need to remember the fact that institutions are run by people, and these people are drawn from our society. And what kind of society do we have? We have a society where a number of us have witnessed injustice, have witnessed oppression, and we've also witnessed those who have benefited from oppression. And the challenge here is for us to ask ourselves, are there times where we benefit from disorder? So what this would translate to, if there was no injustice, would you still be able to draw your salary, for instance? Because at times you find we benefit from disorder. We are like the morticians who benefit when people die. But that would mean for us to have a mind shift. What if we have a perfectly defined society where we have no violations? What would we define ourselves? So we need to interrogate at that. And that means, like in my case, if all states are compliant to human rights, we wouldn't need to be here. and I think I'm comfortable with that. So I would pose the same challenge for us as lawyers in our different capacity. And once we do that, then we would be able to take the next step, which is to say never again. How do we break the cycle of human rights violations? How do we ensure that we have a better tomorrow, that we do not witness violations? And that would call for us to reach out to other disciplines. It's very easy for us as lawyers to interact amongst ourselves. Increasingly, as I grow older in my profession, I marked my bar anniversary last week. I was just reflecting on what can I do differently, and I've gained a deep interest in looking at intersection of language, psychology, and law. And I also want to invite you in the same journey, because I think if we take that approach, we will come up with formidable changes in our society that would be long-lasting. The law will not be existing in a vacuum. And end by looking at an example we have of Viktor Frankl. I know a number of you have read him. He wrote a book, A Man's Search of a Meaning. He was a Holocaust survivor, and he underwent various atrocities. And yet we see him as a person breaking from the mold of being a future oppressor by choosing to be different. So we also have to be conscious about that, even as we call out the oppressors amongst us and those who are oppressed, because we happen to represent them. And it's very easy for them also, having not dealt with the generational collective trauma, to become the ones who go to our institution and they go with that mindset, and therefore we deal with the same problems. So allow me to end on that melancholy note.
Reminds me of what my mentor told me when I started this work is the goal of human rights is to work for a society where we are no longer necessary. And I hope we will get to that place in our own lifetime. We are strapped for time. I don't think we can open it out to questioning. So you'll allow me to close the session. Thank you, Beverline. Thank you, Rubu. Thank you, Evans. And for the insights. Do you want questions? I've been told the time is up. Told us that dissent is not disorder, it is actually democracy. And I hope we'll all find our place in protecting these places. Asante sana.